Hello, everyone. Welcome back to the channel. Attorney Shay here. Today, we've got a hot topic in the world of trademark disputes, and it's not what you'd expect. Mattel, the makers of Barbie, are in a legal battle with an Atlanta based black woman owned barbecue sauce company and restaurant. Yep, you've heard that right. We're talking about the trademark opposition case of Mattel versus Amanda's Barbecue. So, what's this all about? Let's get into it. All right, here's the story. Amanda Kinsey, pitmaster and owner of an Atlanta based barbecue sauce brand and restaurant called Amanda's Barbecue, decided to trademark her business's logo. The logo is pink and features a pig in a tutu with a spatula. Barbecue is spelled Barbeeque. Now, as you might guess, her restaurant name is a playful nod to barbecue, which is traditionally spelled Barbecue, and the spelling is in honor of her grandmother, who actually spelled barbecue in that unique way. Seems pretty innocent, right? Well, Mattel, the global toy giant behind the Barbie doll, didn't see it that way. They filed a trademark opposition against Miss Kinsey, claiming that her use of barbecue, again the spelling Barbeeque, could cause confusion and dilution by tarnishment and dilution by blurring of the Barbie brand. According to Mattel, the names are too similar and they could lead people to believe Amanda's barbecue sauce and restaurant services are somehow associated with or endorsed by the Barbie franchise, which of course it's not. Now let's talk about the key legal issues here. First, priority and likelihood of confusion. So Mattel argues that Kinsey's trademark is highly similar to Mattel's trademarks as barbecue, Barbeeque, as spelled by Miss Kinsey, is similar in appearance, sound, and commercial impression to Barbie, which is spelled Barbie. Mattel also argues that Kinsey's mark is intentionally misspelled, and the spelling choice draws attention to the word Barbie, Barbee, suggesting that Kinsey's goods and services are somehow different than other barbecue items because they are Barbie branded. So I know I'm saying Barbie a lot, so I'm trying to differentiate because we have a few different Barbies going around, but essentially we're focusing on Barbie spelled Barbee, which is part of Kinsey's barbecue. That's part of her spelling. And then we're looking at Barbie, the way that Mattel spells Barbie, which is Barbie. Mattel goes on to argue that the marks would be materially indistinguishable to the average American consumer viewing or hearing the marks in the normal course. So, as the average American consumer, I'd love to know your opinion there. Would you be confused by Amanda's barbecue? Would you confuse that with Barbie? I would love to know your opinion and your thoughts on that. Please share in the comment section. Mattel they go on to mention the color pink, the script, and the fanciful nature of Kinsey's mark, and they say that it evokes the Barbie brand. Mattel also argues that, give me one second. Mattel also argues that it owns at least one registration in each class of 30 and 41, which is forthcoming, and it offers food and beverage goods and services under its Barbie brand at locations including but not limited to various Malibu Barbie themed cafes and pop-up restaurants across the country. So they're also drawing a connection there and saying, well, we do offer goods and services in the food and beverage spaces. So, there again is another similarity that could cause confusion. And they ultimately determine or argue, more or less, Mattel, that as a result of the aforementioned, consumers would be likely to wonder if or assume that Kenzie's goods and services are licensed by or affiliated with Mattel. What are your thoughts on that? Next, the next legal issue is dilution by tarnishment. So, dilution by tarnishment results from negative or unfavorable use of a similar mark or name that by association harms the reputation of the famous mark. So, Mattel argues that its related companies have that Mattel and its related companies have engaged in nationwide advertising, promotion, and use of its distinctive trademarks, and specifically the Barbie mark, for over 50 years. And if Amanda's Barbeeque is registered or used in or in connection with barbecue sauces and restaurant services, it is likely to cause dilution by tarnishment by tarnishing the distinctive quality, reputation, and goodwill of Mattel's famous Barbie trademark. Would love to know your thoughts on that. And so, finally, the last legal issue that I like to review is dilution by blurring. So, dilution by blurring results from use of a similar mark or name that by association reduces consumer perception of the famous mark as a unique mark, therefore impairing its distinctiveness. So Mattel's argument essentially hinges on the idea that Kenzie's trademark is so closely related and so closely resembles Mattel's famous Barbie mark that is likely to cause dilution by blurring the distinctive quality of the Barbie mark. Now, Barbie, as we all know it, is an iconic brand. From toys to movies, even fashion, Barbie is instantly recognizable around the world, and Mattel has been very protective over the years in maintaining their trademarks. They've gone after other companies with similar sounding names before. So, what does Mattel want? Essentially, they're asking the U.S. Patent and Trademark Office to block Kenzie's trademark. They want to block registration for the barbecue sauce and the restaurant services, and they're arguing that Kenzie's use of the name could infringe on their trademark rights. But here's the kicker: Amanda's Barbecue isn't exactly trying to compete with the doll company. It's a small barbecue brand and business and restaurant, and according to Kenzie, she never imagined it would clash with one of the biggest toy companies in the world. In fact, Miss Kenzie, her defense is pretty straightforward. She argues that her business operates in a different industry, barbecue food versus toys, and that there's no real chance that people would confuse the restaurant with Mattel's Barbie brand. I mean, after all, no one's going to walk into the Atlanta based barbecue restaurant or walk up to a food truck and expect the Barbie doll, right? This case really brings up the question: how far should trademark protection go? Is it possible that Kenzie's small business and restaurant could actually harm a brand as powerful as Barbie? Or is this a case of a corporate giant overstepping and trying to go after a small business? As of now, the case is still ongoing, and both sides they're making arguments to the U.S. Patent and Trademark Office. If the office rules in favor of Mattel, Kenzie could be forced to rebrand. But if Kenzie wins, it could send a strong message that small businesses using non competing, unique, clever names won't be blocked by big brands. This isn't the first time we've seen a big brand go after a small business over trademark rights, and it won't be the last. But cases like this raise important questions about the balance between protecting a brand and allowing small businesses to operate without the fear of being crushed by huge corporations. So, what do you think? Should Mattel win the case to protect their brand, or is it Amanda's Barbecue? Is it just a harmless restaurant name and barbecue sauce brand that shouldn't be a problem? Let me know in the comments. I love to hear your take on this. And that wraps it up for today's breakdown of the Mattel versus Amanda's Barbecue trademark opposition case. If you found this video interesting, don't forget to give it a thumbs up, subscribe to the channel for more updates on legal battles, small business stories, and trademark disputes, and hit the notification bell so you don't miss anything. Thank you for watching. I love to catch you on the next one. For more information, you can visit me at www.lawofficeofshayholder.com. See you next time.